AI is fake and gay, as we know. But it's well, after quarter after 3 in the morning here in Connecticut, and I don't sleep so good. I'm up thinking about stuff, and so I am researching my case. You know, because none of this makes any sense. And the fake and gay AI tried to tell me that lawyers are protected even in the event they have knowledge of sexual abuse of a minor because of client attorney privilege. And I was just like, well, that's not acceptable. It doesn't make any fucking sense. So we kept pressing. Let's just read together, I guess. The route piercing privilege via the crime fraud exception. The only pure legal mechanism that shatters the door of attorney client privilege is the crime fraud exception. Legally, privilege exists to ensure a person can confess a past act to get a fair defense the moment a client uses an attorney to commit or further a crime of fraud. That privilege vanishes by operation of the law. To force the lawyer to answer questions under this doctrine, a specific high stakes path must be taken. Establish the fraud in the court or continuous crime. If the mother lied to a judge in sworn affidavits to secure custody or hide abuse, her lawyer filed those documents. A fraud on the court was committed. Yep. The legal logic. If the mother used her lawyer's services to draft and file false statements that put your son in harm's way, her communications regarding those specific filings are no longer privileged. They are active instruments of an ongoing fraud. Shift the battlefield to the district attorney. Family court judges are notoriously hesitant to pierce attorney-client privilege. Criminal prosecutors and the district attorney are not. The legal logic. Child sexual abuse is a felony if the mother actively is covering it up and making false statements under oath. That is perjury and witness intimidation. The action. You or your attorney must present the independent evidence you have to the DA's office. If the DA believes the mother utilized her attorney to perpetuate fraud or shield an active crime, the DA has authority to seek grand jury subpoenas. Well, all I know is that she lied in her affidavit and I can prove it on paper, right? Not to do with the abuse, just that she lied on her affidavit. The in-camera judicial review. If a judge, usually in a criminal proceeding, is presented with independent factual evidence that a client was using an attorney to commit a fraud or crime, the judge will order an in-camera review. The legal logic. The judge orders the withdrawing lawyer to produce her case files, notes, and emails directly to the judge's private chambers, not to you, not to the public. Purity of law. The judge privately reads the communications. If the judge finds that the mother was using the lawyer to carry out a fraud or lie about the abuse, the judge will strip the privilege away and order the lawyer to testify or turn over the records to the prosecution. Okay, that's me. The brutal reality of the burden of proof. To make this route work, the court will demand that you provide substantial independent evidence of the fraud before they let you look at the lawyer's files. You cannot use a subpoena as a fishing expedition to find out if the mother lied to the lawyer. Right. The purest way to protect your son right now, trigger a 51A investigation. If you have not already, you must report the specific details of the Massachusetts Department. Yeah, I've already done that. That's focused on the abuse and right. Okay, here we go. I said I can easily provide a sworn affidavit from the mother, signed and submitted to the court by the lawyer, as well as phone records contradicting her affidavit in black and white. So it's asking for a motion for in-camera review and motion to compel. The court requests you're asking the judge to review the lawyer's communications in private in camera because you have evidence that a fraud on the court was committed using the lawyer's services. The legal argument must explicitly state that you are invoking the crime fraud exception to the attorney-client privilege. The goal, if the judge agrees that your evidence shows a likely fraud, the judge will order the lawyer to turn over her files and emails directly to the judge's private chambers to see if the mother was lying to the lawyer as well. The affidavit of facts, uh, my affidavit, this is a sworn statement written by you explaining exactly what happened. You must walk the judge through a timeline, state clearly the timeline of events, essentially. Um, Exhibit A, copy of the mother's filed affidavit, right? That's already filed with the court. So she filed an affidavit claiming that we didn't have any communication after my son's birth. And she, referenced a timeline of like 9 months, which was completely false. Copy of the phone records, right? And I have a copy of those phone records, surprisingly enough. Where do I file? You must file these documents in the exact same court where your court custody divorce is being handled. Um, it's not a divorce, it's just a custody case, unwed couple. The criminal route, because the mother signed a sworn affidavit and submitted it to a court, contradicting it in black and white proof means she may have committed felony perjury. So we'll see if the family courts can actually address perjury, because it doesn't seem like they like to. You do not have to wait for a family court judge to act. You can take your exhibits directly to the DA's office or the police department in town where the mother is. So I think we're just going to go to the DA's office because the police department in Westfield are questionable. And was the affidavit sent when she lived at her previous address? I don't know. I gotta find that out. Let me go look at dates. Let's see what I want to ask. Oh, is the mother's affidavit stating no communication for 9 months and my phone records indicating otherwise, and the judge's prior finding of not credible testimony, enough weight. Oops. Weight to trigger a DA investigation. High legal practice. Bears why the DA hesitates to step in. District attorney avoids family court disputes. DAs receive thousands of complaints from parents claiming the other side lied in family court. Because custody battles are highly emotional, prosecutors are extremely skeptical and generally leave it to the family court judge to handle penalties like contempt of court and adjust in custody. The high bar for perjury under Massachusetts General Laws, Chapter 268, Section 1. Perjury requires proving beyond a reasonable doubt that the person intentionally made. Okay, so beyond a reasonable doubt that it was intentionally made a false statement about material fact. Defense lawyer will argue that the mother misremembered the timeline or made a mistake, which raises just enough reasonable doubt to stop a prosecutor from filing charges, right? So it's not enough. So that's probably why they said it's risky. Obviously we don't give up. We don't have a quit button. We're trying to find a way to the truth, because 2 hours in 2026 is irresponsible. Me being penalized and not being allowed to see my son because I'm raising concerns about his safety is unacceptable. So just got to keep digging. The fastest route using the family court judge. You do not need a DA's investigation to punish the mother for lying to protect your son. You already have the most powerful tool available, a judge who already does not trust her. File a contempt order or modification. Take your phone records to the family court, file a motion showing that she lied under oath in her affidavit. Because the judge has already found her not credible, the judge highly likely to side with your evidence. Okay. Ask the judge to refer to the case under Massachusetts General Laws, Chapter 268, subsection 4. If a judge in a court proceeding has a reasonable presumption that a party has committed perjury in an affidavit, the judge has the statutory authority to commit that person or notify the DA directly. Okay, maybe we'll start there.